be correct, because they are the decent people who Richard eloquently described a while ago. But the point is that they're paddling against the current, right? And large numbers of these loans are going to default no matter how hard these folk work to stay current. So even if we were talking about cherry picking, I don't think we would be talking about a non-problem here as far as the likelihood of default is concerned. But again, back to the first point, we're not talking about cherry picking anymore because the one plan that was originally talking about that has itself expanded, I think partly at my own urging, I should say. So I don't even know that we've got a real problem here as far as cherry picking is concerned.
Let's maybe get to the expansion of this plan, because I've seen one press release with a page and a half that says we're expanding the plan to non-delinquent loans. How do they do it? Why do they do it? Where do they get their money? What are the mechanics of it? None of those are disclosed. So as an example, let's look at the Kelo decision. Not as a legal context, but as a practical context. So in the introduction, Congresswoman Waters mentioned this seminal Supreme Court case called the Kelo decision. It was in New London, Connecticut, where a private firm came to the city and said, we'd like to make a redevelopment along the water. And we're going to promise all kinds of riches for the city because we're going to redo this waterfront. It's going to be beautiful, malls, and the works. And so the city said, okay, we'll go in and we'll seize people's property and pay them, quote unquote, fair market value. We're going to take people's homes, we're going to kick them out, and then we're going to build this beautiful mall. We're going to turn the land over to this private company who's going to do these dazzling things. Guess what that land is today? Anybody want to take a guess? It's a trash dump. That's what the land is, because the private company backed out eventually. They got the land, the city was able to seize the land, but the private company ultimately backed out because they didn't want to put the capital to work, and now the citizens in that area have a trash dump. So we can talk about the legal aspects of whether the Kelo decision was constitutional, unconstitutional, but you have to look at the practical input. There's a lot of companies that will promise to make these things work, but how do you do that functionally from a financial aspect? How does MRP raise sufficient funds to really make a dent in foreclosures nationwide if they're going to seize these loans? We can come back to the fair market value versus non-fair market value, but as a business matter, how does MRP make money doing this and appropriately fund it?
It's nice to have Tom join the consumer advocacy community. I wonder, sitting on this panel, and I've sat on other panels like this about other proposals that have been out there, every time a new idea comes out, it's easy to poke holes in it and to talk about why it won't work. And we've been sitting here for 6 years waiting to have, there's never been any desire for anybody to prevent a foreclosure from happening in an instance where a foreclosure ought to happen. What we're talking about is instances where foreclosures ought not to happen, meaning where if you restructure the loan, it will return greater value to the investor than foreclosing on it. Okay, so I think we're all agreed that that's what we're talking about. So my question here really is, if not now, when? If not this, what? Because we always get no's, and I can poke a lot of holes in this particular proposal too, but I want to know what the proposal is to actually get done the restructuring that needs to get done.
Well, I'm not sure that everybody on the panel would agree with the point that you made, but if I may throw a question at the panel, or perhaps even make a point, as to whether, if not now, when, the proposal is not one that is financed with public money. It's not as if San Bernardino is going out and selling a general obligation bond at a yield of 5% and then taking its chances buying a bunch of private label mortgages that may or may not be delinquent or in default. It's a targeted plan using private investors' money. If the investors don't think they're going to get their money back with a reasonable return, they're not going to participate. So it seems to me like it's pretty important to know how the plan is going to function and what loans are going to be included. I don't know, is that a relevant point? I would just throw it to anybody because I think that that's something that the audience has to consider. It's not public money I mean, it's not to say that public money can be spent willy-nilly, but it's not like it's a question to be confronted by taxpayers down the road. It's a question to be confronted by investors before they even step into
yes,
this.
investors should do very, very well on this because of exactly what we've been talking about. Fair market value is not going to be fair market value because there is nobody looking out for the existing holders of those private label securitizations. And the result is that you're going to be able to, you basically refinance, you basically buy a $300,000 mortgage on a now $200,000 home at $170,000. By the time you refi and you're able to sell that into the market, the plan basically reaps the difference between $170,000 and $200,000, which they put in their pocket. Meanwhile, the private label investor has been compensated $170,000. They've been way undercompensated, which is why this works so well for the new MRP investor.
Laurie's made that point 3 times now, and I think it's finally incumbent on me to say something in response to it really quickly. So the first is, as Tom himself pointed out, most trustees of securitization trusts do have fiduciary duties, and it's just not the case that you're not going to have anybody arguing on behalf of the trusts for the value of the mortgage loans. Second point is, even if that weren't the case, the courts are not potted plants, if I can use a metaphor that became famous about 20-some-odd years ago. The courts oversee all eminent domain proceedings, and the courts themselves, sua sponte, require that fair value be paid. It's required by definition by the law itself. That means the question is, how do you determine fair value? That's not particularly supernatural either. It's not very difficult, right? There are markets for loans out there. Furthermore, you can impute values to loans that you derive from the prices at which mortgage-backed securities and other such bonds are selling. It's not that difficult to arrive at fair valuations on the basis of perfectly orthodox valuation methods that are taught in every business school in the country and have been taught for decades. So again, we're not talking about alchemy here. It's very easy to determine reasonable ranges within which values can be presumed to be fair. And even if it weren't the case, and indeed it is the case, but even if it weren't the case, the trustees themselves have fiduciary obligations to maximize the values of the assets. Even if it weren't the case, the courts themselves are not just kind of lying around smoking hashish or something and saying, okay, well, if there's nobody contesting the value that's been offered by the condemnor, we're not going to bother about it either. We're not going to oversee it or look it over or criticize it or anything. We'll just give them whatever they want because there's not a trustee here fighting for a higher value. That's just not how the courts work.
Well, let's go back to how the program works. And I think, Bob, it was you who proposed that these loans would be taken by the quick take. Am I correct in that?
There are states that have so-called quick take, yes. And in California, my understanding is that what Senator Bernardino is looking at is quick take.
So they would do the quick take, do the refinance, and then figure out the price later.
No, what you do is you figure out the likely price at the front end, and you have to do that. Then you've got to post that in the form of bond, and then you've got to post a margin to cover any subsequent finding by the court that the original valuation amount wasn't quite enough, right? But the very first valuation that you have to provide to the court as a taker itself has to be plausible. It has to be grounded in orthodox valuation methods. You can't use a Ouija board or whatever, right? You have to show the court, we've actually done our homework here and we've arrived at a plausible value for these assets. Here's how we did it. Here are some business school professors who can tell you that this is a perfectly orthodox method that we've used to arrive at these values. And so we're going to propose that this amount be paid, plus we'll post a margin of 10% above that or some other percentage above that, just in case in subsequent hearings you decide that it wasn't quite enough.
So the structure in San Bernardino is they set up a joint powers authority. It's separate and apart from the city, county, etc. It's its own legal entity. That would be the entity seizing the loans.
Right, yes.
So if the JPA is seizing the loans on the quick take, where they may be posting some margin, but as we're contesting, as you're hearing loud as day.
Can I just interrupt?
Yeah.
Quick take means that the ownership of the loan can be transferred before there's a final decision as to the fair value. Is that correct?
We'll certainly make the argument, and I'm sure trust will make the argument in court if there is a quick take. They will say you shouldn't do it by the quick take. You actually need to figure it out. Let's fight about what the actual price should be. But let's assume for the arguendo that the quick take actually occurs. You come in, you take the loan, you say, we think it's going to be 85 cents on the dollar. We're going to post, 90 cents, and then we're going to push all these loans into refinance. What happens to the JPA if you find out that instead those loans, the fair market value is instead 95 cents? The answer is the JPA goes bankrupt. The taxpayers are on the hook in that circumstance, or the fair market value has already been taken and now lost because you've refinanced it through the process. The JPA, many would argue in legal circles, was entirely set up so that it could go bankrupt, and in fact, there are rumors that NRP suggested it be set up just in such a fashion so that they could take loans on the quick take, and if it was found out later that the fair market value wasn't correct, the JPA in itself would be put into bankruptcy, which of course would leave the investors, again, losing on the fair market value.
It's true that the investors bear the risk, right? That the initial valuation turns out to be wrong.
Which investors?
The people who put up the money in the first place to make the purchases. And that's a good thing, as I see it, right? And I think we all should see it that way, right? But the second point is, again, this is all the more reason for the courts, and indeed this is why the courts typically require that the homework be done well in advance, right? In order that a scenario of the kind that Tom was thinking not occur, that you don't want, sort of find out post hoc that the initial amount that was put up is way, way, way off base. And that is also, incidentally, why the required margin of extra that has to be posted is typically around 10%. It's because you don't usually have scenarios pursuant to which the initial valuation determinations turn out to have been way, way, way off base like that. They require that the homework be done up front. It tends to be done up front, and it's not that surprising that it is, partly because it's legally required, but secondly, again, because it ain't that difficult. Right? Valuation is not that hard.